Well, a very good morning and happy World Intellectual Property Day. It comes our way every April the 26th when we celebrate the ideas which by definition are intangible but make such a difference in all of our lives. In the course of this webcast, we'll be talking about what those ideas are, but also how to make sure that if you're the one coming up with them, that you're actually also benefiting from them through perhaps financially, through licensing agreements, and also building your company around the intellectual property. That seems to be one of the big areas of focus for many governments around the world. What is innovation really if we can't then capture the value of it? We'll be talking about four main themes today. The first is where we are at in terms of IP protection in a region in Asia, which by definition generally does not seem to be, fostering such a great reputation for IP protection. So reputation and protection is the first one. The second issue that we're talking about is the types of innovations that we're seeing in IP. Intellectual property is by definition not a topic that's standing still, and we've got special guests with us to walk us through how to make sure that, keep track of where we're at in terms of those developments. And no surprise, NFTs, non-fungible tokens, those are just one of the many signs of the developments that we're seeing in IP, which we will talk about today. Last but not least, one of the age-old problems that we always have with IP protection is the fact that people seem to be ripping off ideas left, right, and center. As you'd be aware, perhaps, copyright and patent law is really the only way to protect IP, but how can we dissuade and deter people who would otherwise take your ideas from doing so? So we're talking about protection, latest developments, we're talking about latest developments in the ideas, as well as deterrence. Please feel free to interact with us here on the Zoom call. You can do so either by means of the Zoom chat, just drop us a note and we can respond to your questions and comments as and when they pop up. Or the other option is on Mentimeter, and I will flash the QR code again for you in just a few moments. First, though, I'd like to introduce our guests who join us here for the Pitchmark World IP Day conference, focused specifically on innovation and youth. We're joined by a partner in the IP group at Bird & Bird ATMD in Singapore, joining us with more than 35 years of experience working for some of the biggest companies to protect their IP, both here in ASEAN and in Japan, is Mr. Alban Kang. Welcome, Alban.
Right. Thank you.
Also, good morning and welcome from Singapore. We're also joined by our guest in Bangkok, somebody who's been defending the movie industry against piracy for many, many years. Also founder of the Center for Content Protection and a long-term IP litigator from New York, joining us from Bangkok today, Mr. Frank Rittman. Hi, Frank. Good to have you with us from Bangkok. And joining me here in the Singapore studio is our third of our three guests today, also practicing in IP law and in fact representing many companies pro bono in the the Singapore Law Society's pro bono division, somebody who's been concerning himself with those people who've not been able to get their rights by the law for financial reasons is Mr. Cyril Chua. Cyril, you're also former Vice President of the National Council Social Service. Yes. Thank you very much for coming in today. So now a gentle reminder, please make sure that you've got the QR code here for our menti.com poll. If this is last chance to snap the QR code, I'll leave the code to add your comments up here on the screen. And here's the first of the two questions that we'll be posing you during the course of the morning. What keywords come to mind when you think of IP? Very simply, go to the QR code or the Menti code here at the top of the screen and add the three words that spring to mind when you think of intellectual property. And we'll give you a few moments to add your keywords. Meantime, let's focus on the state of IP, and in particular, you know, that first topic that I mentioned a few moments ago. Alban, when we talk about the developments of IP, when we talk about where the law is at, where are you seeing it right now?
Well, that depends on where you're sitting in, I guess, in the region. I mean, as you mentioned, there's the laws in the region is varies, and I would say, for example, in Singapore, we do have very strong IP laws. In fact, they've just amended or they just reenacted the copyright legislation to take into account some of the new developments in technology. On the other hand, you get some other countries, maybe some of the less developed countries like Laos or even Cambodia, where the laws are not that great, probably needs further development in those areas. So I would say that the protection of IP varies from country to country, depending on the state of development in that particular country.
That's the state of the law. Has IP itself evolved in your experience over the last 35 years?
I think it has, and it runs tandem with the law. I mean, take for Singapore, for example, as we enhance IP protection in Singapore, you find that the level of innovation has risen. There are a lot of new, I would say, local Singapore innovators coming onto the market, more patents being filed by local inventors and local innovators, you know, more protection being sought by local entities as opposed to the multinational companies that are operating in the region. On the other hand, if you look at some of the lesser developed countries, because there's so little protection given to IP, you know, there's no incentive really to innovate. I mean, you might as well just copy, save yourself the trouble of trying to think of something new. You know, just copy an existing idea.
Wow. And for Frank, for you in Bangkok, can't help but feel that perhaps Bangkok and Thailand is one of those countries that's still gearing up with its IP protection. What's your experience been there?
Actually, the state of the law and the state of enforcement is actually pretty well developed. There's a specialized court in Thailand that deals specifically with intellectual property offenses. But behaviorally, I think it's largely still an unknown topic, particularly for kids. Mark, when I was listening to you and you were asking the latest, you know, sort of innovations, two things that struck me over the last, say, 15, 20 years. First, the state of technological development. The fact that, you know, kids these days walk around with these phones that have such a tremendous ability to innovate and create recording devices, cameras, the ability to get stuff up and out there. And just the younger generation's ability themselves to multitask and to manipulate and utilize this technology. They're better with computers than we are. So I think that's sort of laid a tremendous foundation for innovation to flourish. But to your question, as far as the state of the law is concerned, I'd say Thailand's definitely above Laos and Cambodia and Vietnam, perhaps a step behind Singapore, but right up there.
Well, that's good to know. And Cyril, for us here in Singapore, of course, we have a reputation for IP protection, but in practice, what are you seeing in terms of the behaviors?
Well, it's always a constant tussle between the IP creators and the IP consumers. But what we sometimes fail to realize is that the creators are also the consumers of IP. So when you're on the side of the creator, you want stronger laws to protect what you have created. If you're the consumer, you want to have more fair use of the created IP content that's easily available. Now, the law, I believe, had not really caught up with the change in the demographics and also how IP is consumed. Now, if you take this back like 30 years ago, it's always the creator and then you have the consumer, and the battle is just between the two. Now, over time, what you see is that you have the aggregators, right? The e-commerce platforms have taken a significant power in the demographics, in connecting the IP creators and the consumers. And you have your YouTubes and all the content aggregators over the internet, and they have had a significant power in the dissemination of IP. And if you look at the law, they don't seem to have the responsibility, or at least the weighted responsibility they should have in the protection of IP. And over time, I believe that the law would have to evolve to impose more responsibility on these aggregators so as to make sure that they behave properly, I would say.
But the aggregators almost by definition have such a tough time doing so, right? Because they're collecting content from so many people. And you often hear people on YouTube, YouTube creators complain that even their own content YouTube takes down.
Yes. So, but the powers of them, because they have all the algorithms and which they could use to help to take down some of the infringing content. As to the extent they are prepared to do that, it's still questionable. The other possible issue is royalty payments. How much YouTube is paying the creative industry versus, say, Spotify or iTunes. I think it's still questionable.
They should pay more.
They should pay more, I believe.
Yeah. How much are people actually getting paid at the moment?
Well, I don't have the actual figures, but I believe that based on the number of downloads from YouTube versus Spotify or iTunes, I believe that YouTube is getting off a little bit easier.
Right. Yeah. Because, you do also hear artists who are on Spotify complain about the fact that Spotify doesn't even pay them large amounts of money. When you think of some of the singers who, what do they earn? Alban, do you happen to know? Is it 0.00002 cents or something like that per download? Isn't
well, I guess the difference is that, say, Spotify and iTunes are subscription-based services. So you could quantify what they get from the subscribers and how much they pay to the creators. Whereas I guess in YouTube, you have everyone uploading and then downloading content. And it comes to a point where YouTube has the bargaining power saying that, look, this is all we could have. We could pay you, take it or leave it. I mean, that's probably their stand.
Yes. Well, Google takes, and I guess everybody else leaves it. Gentle reminder for you to please contribute to the poll. Right now, we're asking you what 3 keywords spring to mind when you think of intellectual property and IP protection. Please join us here in the conversation by using the QR code that's currently on your screen. Alban, what's been the experience for you? I mean, has there been an improvement in the sort of recognition of the IP value that people bring along? Are large companies paying more for it?
I wouldn't say there are large companies paying more for it. I think the value of there's been, I would say, a greater recognition of IP rights, at least in Singapore. And so people do respect IP rights, and people do, inquire about the need to maybe pay for or compensate the right owners for the use of the IP. So that's a result of, I think, how the Singapore government has promoted IP in the last couple of years. They start at school level, and I think that, and of course, the theme of today's topic for World IP Day is IP innovation among the youth. So what the Singapore government has done really is to start educating students at school level about protection of IP and IP rights, and so develop a sense of awareness among the younger generation. And so that's become almost ingrown here in Singapore. And I would say, most Singaporeans and most of the younger generations are fully aware of, the IP rights and the need to protect and respect IP rights.
Cool. A quick invitation to Ruth and Nestor, 2 of our viewers who join us today. Please feel free to jump in with your comments and your questions as well. Just click raise hand. So you navigate to the bottom of the Zoom screen where it says reactions, click raise hand, and we'd love to hear your comments and input as well. So Alban, of course, the one thing that everybody's talking about right now is NFTs, non-fungible tokens. opening comment. I see you smirking already. What are your thoughts on this latest development? Are they just receipts that people are spending a fortune on, or is this really a new asset class of IP?
That's what I'm smiling about. I'm not too sure. Is it just flavor of the month or flavor of the year, whatever, NFTs? At one time, I mean, it's like a bit like cryptocurrency. At one time, there's a lot of buzz about it, and then it sort of dies down, and then it picks up again. I think there are issues with NFTs from both the right holders perspective and the end users perspective. Maybe I'm from a different generation, but I just find it difficult to fathom or understand why people would pay so much for NFTs. So that's always been a question in the back of my head. But with NFTs, there come a new range of challenges, new issues and challenges when it comes to protection of IP rights for the right holders. Yeah. And I think that's something that's developing along the way. Yes, Frank, you wanted to add something?
I think the most important observation, there is so much hype and misunderstanding about NFTs. And I think the essential thing to point out is that the purchase and ownership of the NFT itself is separate and distinct from the purchase and ownership of the underlying IP.
Of course.
If you buy one, you don't necessarily get the other. And I think that's a real contributor to the misinformation that's out there right now. But yeah, to your point, Mark, NFTs, that's a really new, sexy, exciting sounding word, if anybody can really explain to you what it is.
Cyril, can you?
Well, I look at NFTs, not so much of an IP issue. If someone is prepared to pay millions for the first email sent, well,
the first tweet.
Oh,
Jack Dorsey's first tweet.
Yes,
right?
the first tweet. I mean, well, good for him. Just like I couldn't understand the value of this sparkly little rock which you put on the ring. For me, it's
Does your wife understand it?
well, I mean, don't tell her about that. I don't think much about the little sparkly rock because essentially it has no intrinsic use except that it's pretty. So for NFTs, it's the same thing. I mean, someone wants to have the first digital copy of a particular item, and they date it, they stamp, they mint it, and then they price it. And if there's a buyer, then there's a buyer, then there's a seller, and ta-ta, there goes the value, right? Now, would the value sustain? Well, only time could tell.
Whereas a diamond is forever. I guess that's the...
That's what they want you to be.
That's what they... Oh, it's still not forever. I see. Well, but, arguably an NFT is also forever for as long as you've got the code, isn't it?
I mean, basically, it's you have the code to date, time stamp it to know that is the date of the minting of the digital asset. So there is it. But if you look at it, it's just an expression of an IP, right? The initial tweet, the words, it's created by Jack Dorsey, and he owns the IP to his tweet, right? This is just merely the first digital format of that tweet.
Isn't that just the problem? First Cyril, then Alban, and then Frank. Isn't that just the problem? The fact that you actually have ownership of this tweet or whatever the digital item is, but not the copyright to it. How is it possible to actually split the copyright from the ownership?
Okay, think about this. Now, assuming I am the artist for Amazing Fantasy number 15, that's the first edition of Spider-Man. Right? Now, I own the copyright because I drew that. I drew the Spider-Man for that particular comic, and you bought the first copy of it. So that first copy is worth probably millions. So you have the first copy of Spider-Man, right? But I still own the IP, right? To the artwork, you owned the actual physical copy of the comic. So that's where the difference is.
Okay, but when we now transfer that into the digital environment, the first copy is inalienable, presumably, right? Because you've got the copy, it's there in your hands, in hard, or rather in your gloved hands, because you wouldn't want to handle the first copy, right? And then you turn the page and you can tell all your friends, look, here is the first copy. Look, it's even got the stamp on it to say this is copy number 1. The problem with the NFT seems to be that you can copy this damn thing ad nauseum and nobody can tell that it's the first one.
Well, so they can track through the blockchain technology that you have the first digital copy.
But where are the bragging rights? Where are the nice white gloves to hold it with?
Well, it's a matter of preference. It's a matter of some would like to brag that they have the first digital copy, and that's good enough. but I'm not sure, is that really good enough?
Alban, would that be enough for you?
Well, this is exactly the issue that I have with NFTs. You see, and as what Frank said, you may own the physical token or the digital token, but you don't own the IP right. So what do you do with this NFT? I mean, it's unlike, say, I buy the Mona Lisa itself, right? The painting, a physical painting, I owned it. I may not own the copyright, but I can sell the painting and I can deal with it. In an NFT, I'm just wondering, what there's so much value placed on it being, for example, in Cyril's example, on the first digital NFT. But what can you do? Because the moment you try to pass it to somebody else, you are actually reproducing the NFT, and you may actually be infringing the copyright, infringing the IP rights, which you do not own. So you can, yes, maybe it's just bragging rights. You can have it, but that's all you can do with it. And that's I've always been the big question: why is there such a great demand, and why do people pay, thousands of dollars for something like that? Maybe you're right; it's just the opportunity to hold it with white gloves. But what else can you do with it if you don't have if you don't have the IP rights?
Exactly. And Frank, you and I have talked about this at some length. I see you sighing, heaving a sigh.
Just that, at the end of the day, buying an NFT is no different than going to an old record store if you can find one and buying a compact disc. You get, as the panelists have said, an expression of the underlying concepts, the original works. And, rights owners have traditionally used, as they put their works out into the marketplace, use various tools to control and distinguish the difference between the underlying creation and the express copy. They use terms and conditions. If you buy a DVD, it's expressly telling you what its purpose is for and what you can and cannot do. And this is the rights owner's attempt or actual ability to state out what the permissive uses of that are. And then we just heard about the technology as well. It is possible in a digital context to put out digital copies of works and limit their further use and distribution through such things as technological protection measures and other things that are also protected by law. But yeah, I think it's what's an NFT worth? It's worth whatever somebody is willing to pay you for. What's my house worth? What is my house worth? It's whatever you're willing to buy it from me for. Does it mean it's got any inherent great value like gold or something that's traded on the world market? Not yet. And then I think the last thing you were just talking about the other copies. We are seeing issues emerging now in terms of fraud with respect to NFT. People taking other people's creative work and holding it out as their own, selling NFTs of those other person's creative work. So I think there's just a lot of hype and confusion at the moment, and it's a great topic for discussion.
Yes. Indeed, which is why we're here. Ruth, you contributed also to our word cloud just now. For you, IP means copyright, creation, and ownership. If you are yet to contribute, you're very welcome to using the QR code there, rather the 8-digit Menti code at the top of your screen. Other topics, other words that you've put into the word cloud, creativity, protection, that seems to be getting the biggest word, rather it's the word that's entered most often. And you can see the others here on the screen. Ownership, royalties, often stolen. Ain't that the truth? Thank you for your contribution if you're the one who added that. So how much is it worth, right? That is the, thank you for all your contributions and keep them coming. How much is it worth? That's the question Frank asked just now. I guess the difference between, a house, as Frank was saying, and an NFT is that you can actually live in it. Mm-hmm. What can you actually do with an NFT, considering that you can't even hang it on the wall because it's a digital asset, Cyril?
It's bragging rights to have the first tweet, digital copy of a tweet. So what would happen is that you probably have the digital copy, you save it into a medium, and that's what you could claim you have, a digital copy of the first of something. You may not have the rights to reproduce it, but you certainly could sell your hard disk or your medium away, saying that here lies the first copy of the first tweet ever made. And if someone's prepared to pay for it, so be it. It's a lot like owning the first Spider-Man comic or the first Fantastic Four edition or something like that. You have the first one.
Gosh, here lies the first copy. Goodness, that sounds terribly.
Yeah, I know.
Just a little bit more.
I'm not a big fan of NFT. I do things to some extent it's a fad. Everyone is rushing in to create or mint their own NFTs.
Mm-hmm. Have your clients asked you for that as well?
Yes, they have. I mean, they asked asked me to protect the NFT. I said, look, you don't need to protect it because if you are the creator, you own the copyright to the underlying artwork or the literary work. You own the copyright. You don't need to have a special registration for an NFT. And if someone's prepared to pay you for your first digital copy, then that's all well and fine. In fact, what they try to do now is that they would try to mint the NFT at a particular date and time, which appears to be auspicious, like the 22nd of February, 2022. So it's all 222-202.
Yes.
And we know that there are some calligraphers who would write some auspicious words and would mint an NFT on a particular time and date, on maybe at the 22nd hour and 22nd minute, and they mint it at that time, and they say, hey, they sell it. And there are people who are prepared to pay money to buy these NFTs.
So as you in your role at the Law Society's pro bono services, those community legal clinics, have you even had this question come up there?
Well, not so much of the community legal clinics. There is also a separate IP clinic, which I do take some cases. And so some of the cases we get is not so much of NFTs, but jokes or something funny that's created. Then the creator put it on Facebook. It's really funny. It goes viral. And then suddenly someone tried to exploit it to make money of it. And then you have this creator saying, hey, that's my joke. And now it looks like you're selling it, you are modifying it, adapting it, and they want something for.
And what do you tell them?
Well, I have always said that it's always difficult to claim once it's all in the internet, because you have multiple infringements. Now, no one's going to pay you if all they did is to forward your joke or put it somewhere else. But should you find someone who's actually making money of it, well, go right to them and try to get something from them, because clearly you are the creator of the work, and they have reproduced it or adapted it without your permission. Try to get something from them.
Wow, and they come to you at legal clinics. Are the jokes at least funny, the ones that they're worried about?
Well, yes, actually there is. I'll share this with you after the program.
Oh, really? Otherwise, I guess there'd be copyright issues. Gentle reminder, we're about halfway through our conversation today, so please make sure that you add your comments here in the chat, or if you'd like to raise hand and contribute to the conversation, you're very welcome to. We'll unmute you or invite you to unmute in case you don't want to type your answer. Alban, to some extent, NFTs split copyright issues from property law. Is an NFT, I mean, for example, the joke that Cyril just talked about. I mean, the fact is that just retell the same joke a little bit different, and already any would-be comedian is able to rip off your idea for the joke. I mean, to some extent, the fact that an NFT gives you a value under presumably a different part of the law, does that help to protect this joke or whatever the IP is?
It really depends on the type of IP protection that you're seeking. I mean, take for example copyright law, which probably protects most tweet comments, drawings, pictures, musical works. Copyright protects the expression of the idea. I think that's generally how it is termed, and not the idea itself. So I mean, you can tell multiple of Irish jokes all in around the same theme, but you may not be infringing anyone's copyright. So I mean, the classic example is Romeo and Juliet, for example. Two lovers from warring factions falling in love. That's the classic Shakespeare's Romeo and Juliet story. But then you also have West Side Story, which again, along the same themes, but it's an expression, it's a different expression of the same idea. So that's where copyright protects the expression, but not the idea. And that's why you can see nowadays, there's so many versions of West Side Story coming out, or even in some of the Korean or Chinese drama series. Yeah,
well, we've talked about diamonds. Why not West Side Story? But I guess the problem or the question is, especially for those of our Pitchmark members, of which we have hundreds, who are all concerned about their ideas being ripped off by prospective clients who they pitch to. Is there not a case to say, well, even if you copy the idea, I still retain the ownership? Does that play in the minds of the recipients of the idea that, yeah, it's not as simple as to just rip off the essence of Romeo and Juliet?
Again, this is probably boils down to the terms and conditions of use, as Frank and Siva mentioned. It really depends on, what were the terms and conditions that was agreed upon when you parted company with the property, in this case NFT or whatever. So if there is some kind of condition that prevents you from using the same idea, then it becomes the protection is more contractual rather than on the IP side. But of course there are other IP protection that protects the idea, for example in patents, but that doesn't really apply so much to NFTs. I think NFTs, the main form of protection is really it's copyright. Yeah.
All right, Frank, any final comments on splitting copyright from patent, rather from property law?
No, I think we've covered it.
And you weren't at all offended about the Irish joke comment just now, right?
Not Irish. No offense.
Not Irish. Okay, cool. Final call. If you'd like to jump in on this conversation, please do so. Just unmute or raise hand and we will invite you to unmute. You're also welcome to pop questions into the chat function of Zoom and we will get those to you. Here, meantime, is the next question that we're asking you. Earlier, it was about what words spring to mind when you think of IP. Now, let's talk about the standard of IP protection in whichever country you're from. Nestor, Ruth, you might like to comment on, I gather you're in the Philippines, you might like to comment on the standard of IP protection in your country. And while you go and vote for that, so please remember the Menti code there at the top of the screen, 3567-6239. Let's talk about the standards of protection litigation. Are you finding, as we go into these more nebulous areas, YouTubers who are making, or TikTokers who are making a fortune of some of the things they put online, and yet it's so easy to share, so much easier to share than when you and I were at school, for example. I mean, has the protection kept pace with the incredible rate of distribution opportunities?
Well, not exactly, I must say. It's still fairly easy to download infringing items, movies, because the problem with the law is that it's jurisdictional. Right? Now, if you know that the IP is being infringed in Singapore, well, that's great because the laws are strong here, the practice is strong. But if it's in, say, somewhere else, like it's in Russia, right, where it's being infringed and the material could be easily downloaded in Singapore, then it becomes a lot more difficult to stop the infringement. Of course, the laws have evolved where you could do a site blocking application to stop them from, to stop a particular site from broadcasting infringing materials into Singapore. But these are all very expensive applications. So unless you're a big corporate entity, you're unlikely to be able to afford these remedies. Now, what is interesting is that within the region over here, the IP laws are fairly uniform. I would say about 70% to 80% similar. If something is an infringement of an IP in Singapore, it's likely to be an infringement in Vietnam or Thailand or Malaysia. But it's the enforcement mechanism and the practice of the law, it varies from country to country. So while it might be easier to enforce your rights in Singapore, it might be more costly or more cumbersome to enforce it in some other countries in the region.
funny that you should mention Russia, because they seem to be infringing on a whole lot of things. Copyright seems to be the least of them at the moment. But in Singapore in particular, where people have been encouraged to regionalize, to tap markets overseas, how well do you think this is understood by your clients? How difficult it is to enforce?
I don't think it's very well understood, because you do not really understand the hassle of enforcement until you go through the process. Right? Initially, you have they explain the law to you, so you look at it theoretically. The law is fairly similar to Singapore, about 70–80% similar. But when it comes to enforcement, dealing with the legal systems or the administrative systems in these countries, that's when you find that, oh, it's a massive headache. And it's more expensive to enforce your IP than the loss you actually suffer from the infringement. So when you weigh the cost-benefit approach, you realize that, oh, it's not worth enforcing. So that happens quite often.
And Alban, you also handle multi-jurisdictional cases. What's your experience been?
Yeah, it really depends. There are challenges in certain jurisdictions, and you just have to, ensure that that you choose the appropriate enforcement strategy for each and every country where you're enforcing those rights. Maybe I should just now mention about Singapore. Singapore now has introduced a new set of rules to deal with IP enforcement, litigation, especially in the courts. It's known as a fast-track IP procedure, whereby you could enforce. Well, the theory or the rationale behind the new change is to allow companies to enforce the right holders to enforce their IP rights within a short period of time. So within 2 years, you will be able to get, hopefully, some kind of judgment from the court. So this is something, it's like a fast-track court procedure, which would limit the legal costs involved and would then hopefully encourage more right holders to actually consider taking enforcement action, rather than saying, oh, it's too expensive, as what Cyril mentioned, it's too expensive to enforce, I'll just let the infringement go. So hopefully this new rules that has been introduced into the Singapore court system will benefit some of these right holders. Yeah, so it really depends. For some countries, it may be easier to enforce the right. Some countries, it may not. And it also depends, as Cyril mentioned, it's not 100% the same in every country. Some countries may protect this form of IP, another country may not, for example. And so then you are left with trying to find alternative remedies in those countries.
Okay, well, let's drill down specifically to the Philippines and Indonesia, where many of the Pitchmark members are. And in fact, Ruth and Nestor, I highly suspect you're both in the Philippines. What's your message then for people outside of Singapore and in terms of IP protection in an environment where it's so much easier and faster to copy and distribute your IP? Alban.
Oh, you're asking me?
Yes.
I think what we found, I think one of the common issues with Philippines and Indonesia is the bureaucracy that's involved in enforcing IP rights. It takes a long time for matters to move along in the court or administrative system, and that often is also a deterrent, because you can't get quick, efficient remedies in some of the cases that you want to push in those countries. So that has always been a challenge.
And you represent very large companies, which presumably have all the resources at their disposal to enforce these. After all, that's why they engage you. So are you finding that it's a matter of resources, or is the large company just as much at the mercy as the little guy?
Yeah, it's not a question of resources. It's a question of how the system works in those countries. For example, it's very hard to get hearing dates. The courts are very easily inclined to adjourn matters at the request of the other party, so things just get dragged on. And for example, in the last 2 years, as a result of pandemic, no hearings are held at all. So it's even difficult to fix an online hearing. So so you get issues like this arising in some of those countries. Yeah.
Right. And Frank, in Thailand, you mentioned there's a special court set up. Has that actually been able to sit during the pandemic?
Courts are back open up now. We're pretty much open for business across the board. I guess what I was thinking of, I was bringing it back more towards youth. And I was thinking as I was listening that, 10, 15 years ago, the piracy problem, if you will, I guess let me start over again. When I think about youth, I think about the phenomena that youth is often engaged in copyright infringement and piracy, one way or the other. And when I think about 10 or 15 years ago, the problems that the industry had were largely around pirated DVDs. So when I was working with the Motion Picture Association, the kids who were selling these pirated DVDs on Sukhumvit Road, the people selling them were often kids, 14, 15, 16 years old. And when we would enforce against them, they would be brought up in front of these specialized courts. And the tendency of the judges was to, as Alvin said, not really push for full enforcement, maybe give them a corrective youth order or something like a weekend detention. And it really didn't have a tremendous amount of deterrent effect. But the phenomena over the last 15 years is the problems have gravitated off the street and online. So a lot of the youth that are engaged in illegal downloading or sharing, if you will, on online platforms, what can be done to enforce in that realm? Well, I guess it was the United States, the record industry took an attempt to bring civil actions against downloaders under the copyright law. And it was just a public relations disaster because, again, the court of public opinion was that the penalties for downloading music that were being assessed against, in many instances, kids, teenagers, were just prohibitive and overboard. So what an interesting sort of enforcement mechanism that applies kind of on a convenient basis now, affects kids as well as adults and goes across borders, is in fact site blocking. And it's a phenomenon that goes on in Thailand and as well as in Singapore. Rights owners can get administrative orders to have internet service providers deny access to sites like the Pirate Bay or popcorn.com, what have you. And, again, this is a way to deter youth from infringing in piracy in a cost-effective and meaningful way that might have some sort of long-term deterrent effect, but that doesn't see them ending up in jail and that takes it out of the unpopular realm of public opinion.
Nodding vigorously next to me at everything that you've said so far, Cyril. Any multi-jurisdictional comments that you'd like to add?
The laws are very clever, but they all work very well for the big right owners. Now, assuming that you're a kid and you're a YouTube or TikTok content creator, now would this kid have the resources to take the infringement up to court and get its remedy, even with the expedited system in Singapore? No, unfortunately. I would say that the cost is still too prohibitive for, if you're just a small content creator over YouTube or TikTok, you wouldn't have the resources to take an infringement action through the Singapore courts or any courts in this region. Now, increasingly, as I've emphasized, the powers are now with TikTok, YouTube, that they hold the control of how contents are being disseminated, just like why Elon Musk want to buy over Twitter, because with that, he holds the pipeline to where Macron and Trump and all the world leaders, how they disseminate to their supporters. Right now, more responsibility must be placed on these content aggregators. And they should be able to be in a position to block or stop the infringement, independent of having a site block order, because there's no way a small YouTube or TikTok creator would be able to afford a site block order to block some of these contents.
Yeah. But, Frank's point also about the kids, when we're talking about kids, I guess we're talking about people younger than us, in their 20s, 30s, and 40s.
Yeah.
You know, the fact that they are themselves creators of content. Are you seeing a shift in the mentality that perhaps they are more cautious about downloading content illegally because they recognize that they themselves might be next to have their IP infringed?
To some extent, yes, but ultimately they're more bothered with the stick than the carrot, right? If you were to look at the history of Singapore, 15 years ago, the police actually did a sweep against illegal downloads, and they caught a lot of students, essentially from tertiary students to secondary school students, and immediately they had a really negative public reaction against what the police did. And they said, well, I mean, what's the police in Singapore doing? They're robbers and crooks, but you go after kids illegally downloading music. So that was the only case the Singapore police did. Now, then if you do go a few years later, you have some of these cases like the Dallas Buyers Club cases, where a lawyer was engaged by the licensee of a Dallas Buyers Club, and they were taking action against illegal downloaders in Singapore. I mean, the legality of the action or the method which they employed is somewhat dubious, but still it created a lot of awareness. And then you find that the public stopped downloading so many illegal content. So that helped to some extent educate the public on illegal downloads. As for finding a true altruistic reason not to download, I think illegal content, I think that's still quite hard to come by at the moment.
Yeah. Alban, is that also your experience, that young people are not making that connection yet between the fact that they are themselves creators and pirates at the same time?
Yeah, there's some truth to what Cyril is saying, that sometimes, you know, they're not sure themselves as to you know, whether they want to be innovators or whether they just want to be copyists. But as I said, in Singapore, the problem is less prevalent because, you know, of the grounding that most of these young students and younger generation have had in their school days.
Okay. Well, in the Philippines, Indonesia, we're seeing a lot of web developers, for example, graphic artists, people who are working from home join the gig economy. They list their services on freelancer.com, fiverr.com, upwork.com, and so on, and then actually have some, on many occasions, very large multinational clients who outsource those sort of services to them wherever they happen to be. Let's take the Philippines as an example. So because the internet and these various gig economy platforms allow them to contribute their IP to very large companies, are you seeing a change in, or could that be one area where a change in perception of IP and the need to protect it could be brought about?
Yes, definitely. Again, you know, it's at the end of the day, it's a bit about awareness. And once the innovators or some of these gig economy entrepreneurs, you know, realize that they have IP rights that can be protected. It's a matter then of negotiations, you know, for ensuring that, you know, terms and conditions that they enter into with the MNCs do give them some form of protection of IP rights.
Okay, we are heading into the final couple of minutes. So another final reminder for you to please join us here in this conversation. Raise your hand and you're welcome to unmute and join us in this conversation. And you can also see here on the screen how you've voted so far. How would you rate the standard of IP protection in your country? And well, we have got a couple of votes towards the very strong angle, but most in the middle, which is why, of course, at Pitchmark, we always talk about deterrence. How do you persuade the person you're pitching your idea to, whether that's a piece of graphic design or an architectural drawing or whatever happens to be? How do you influence them to not rip off your ideas rather than go the hard yards that we've heard over the last hour? You know, the cost of IP litigation. Alban, you were talking about the incredibly difficult bureaucracies on occasion that you face. How much more could you actually do you think, first Alban, then Cyril, on deterring idea theft proactively rather than having to litigate reactively? Alban.
I think education's the way to go. Essentially, you need to start with again, the younger generation. It's bit of moral training, I guess. What's right, what's wrong, and educating respect for IP rights. So once you start that, that's the earliest form of deterrence, and then inculcate in the younger generation a sense of of respect for the creativity of others. And I think that's the way to start. I mean, using the stick when it comes to enforcement is a bit too late. That's not really going to deter because the mindset is already there, But if you start them young, with a different mindset, there's respect others, respect the rights of others, respect the creativity of others. That I think is a greater form of deterrence.
Mm-hmm. Okay, but that's very much on the creative side, right? What about on the receiving end, the client side? Are you finding with the very large and sophisticated companies that you're working in that they have the level of education needed to respect IP?
I think they do, and in fact, for the large MNCs, they're very concerned about ensuring that their own they have internal guidelines about for their employees to ensure that their employees, respect IP rights of others, not only their own IP rights, but the IP rights of others. So I think from the large MNC's perspective, it's not a question of deterrence. It's a question of, I would say it's acceptance, that IP needs to be protected.
Mm-hmm. Cyril, your experience?
Well, I think when you're out in the commercial world, you deal with bullies. Everyone knows the law. Putin clearly knows the law. Still, he sent troops into Ukraine, right? So everyone knows the law. Now, in the commercial world, you deal with bullies. And the current standard of protection is to get someone to sign a non-disclosure agreement before you disclose your idea. But it comes to a point where some of these non-disclosure agreements, they are often signed, not really taken seriously. So what I really appreciate is what Pitchmark has to offer. I think that's an interesting proposition. If you show that you have deposited your ideas with Pitchmark and you make it clear to whoever is receiving your idea that you have deposited your idea with Pitchmark, it shows that you are really serious in protecting your idea, and it shows intent that you will enforce your rights should your idea be ripped off. Now, the recipient of your idea would then be more circumspective before they do decide to so-called borrow your ideas or use it. So yes, so I hope that what Pitchmark offers to the public would be helpful to ensure that there is more fair play.
So wield the stick before you use it. Show them that you have one.
Yes,
I guess
precisely.
is the point.
Yes. If Ukraine is probably more better armed and Russia knows about it, maybe there will be no invasion.
Yes, deterrence might have, well, I guess they tried to deter, funny you should say that, because Pitchmark is about deterrence by shining a spotlight on the prospective offender. Isn't that exactly what Joe Biden tried to do, right? By, as recently as at the beginning of this year, is to talk about Russia's troop buildup before they had the chance to.
Yes, but Ukraine still looked too weak to defend itself. So right. Putin felt that they could get into Kiev within like a few days.
Yes, and look where that ended up.
Yeah.
Okay, final invitation. Jennifer and Tessa, thank you also for joining us. If you'd like to join the conversation, just raise hand and unmute. And in the meantime, I'll invite Frank to perhaps wrap up with some of your comments on what young people must do in order to deter idea theft and make sure that even as they are borrowers of certain IP, that they also become more staunch defenders of it. Frank.
I think with respect to education, you really got to start them young. I think you were mentioning before 30s, 40s, way too late. By the time someone's 18, it's too late. The patterns are already ingrained. they're not going to think much more about it. So what we learned at the MPA is you have to start really, really young, grade school. And you do it in whatever ways might relate to them. We've tried out a number of things, comic books, messaging, movie trailers that we put on, dogs that we trained how to sniff out DVDs that we took around to schools around various countries in the world. But I think to the points that were raised and to a question I see that's come in, Pitchmark is a great way to build up awareness that hopefully will influence behavior and change deterrence. It's a question coming in from Fran. What I'm interested in is how do you protect your pitch for screenplays, books, shows? What would you do? Just what would you share with someone in a pitch session in a literary convention, books and screenplays? And to Cyril's point, that's exactly, I think, what Pitchmark is a great way for young people to start building awareness about it. Once they see the Pitchmark logo, the colors, they build an awareness of what it represents and what's expected of them. That whole community that's built around it, the lawyers who are registered with Pitchmark, the innovators that use it, the clients that receive it. This is the great way to build awareness that will hopefully build towards deterrence.
Awesome. Thank you very much. We'll leave it there. Frank in Bangkok, Frank Rittman, Pitchmark legal advisor and patent attorney. Thank you for joining us from Bangkok. Orban Kung, thank you also. And for your valuable time, your partner at Bird & Bird ATMD in Singapore. Greatly appreciate your insights today. And Cyril Chua, thank you for joining us as well from the Singapore Law Society and in your esteemed roles in the legal field as well. And for those of you who were watching us, thank you again for joining us. Please go to pitchmark.net, sign up, it's free for innovators. For lawyers, tap into the hundreds and hundreds of innovators who need your help. Join us on pitchmark.net as part of our global legal network. And hopefully we can all raise the bar on IP protection on this World IP Day. Hopefully we can all raise the bar on deterrence and greater respect for intellectual property. I'm Mark Lowdy here in Singapore at the Pitchmark studio. See you next time.